situation, right? So what kind of assets are we dealing with? What kind of take money off the table, but we can't fully remove it altogether, right?
Sure.
There are a lot more streamlines here in Colorado. If we're looking at other states, $500,000 to,
All right, and welcome back. This is the third video in our video series. I'm Keith Alba with my home team, and this is Renette Greer with Greer Law.
hello again.
Back talking about probate, living trusts, all that kind of stuff.
Yeah,
right?
absolutely.
We've done 2 other videos in this series, so if you haven't seen those, make sure you go back and look at those. Great topics, great information. I think so, at least, right?
Yeah, as do I. That's why we're here, right?
Right, exactly. Perfect. So let's talk a little bit about costs, right? That's
absolutely.
obviously going to be questions people are concerned with. Which one's cheaper? Which one's better? You know, how do you kind of direct your clients to which path? Was it the will and probate, or maybe a revocable living trust?
So I think I mentioned the first thing they teach you in law school is to answer everything with "it depends."
Right.
So it depends. So you know, it kind of, in deciding whether we are doing a will-based estate plan or a trust-based estate plan, really will come down to the individual's situation, right? So what kind of assets are we dealing with? What kind of concerns do these people have? But then, you know, aside from that, right? And I always say, you know, let's take money off the table, but we can't fully remove it altogether, right?
Sure.
You know, so you know, because Colorado has adopted that uniform probate and trust code. Things are a lot more streamlined here in Colorado. If we're looking at other states, you know, things get tied up for years. Attorneys' fees are astronomical. You know, here in Colorado, attorneys are not allowed to charge based on a percentage of the estate. A lot of other states, that's permissible. So here, again, those costs are, you know, we're not paying, you know, $500,000 to, you know, settle, you know.
Right, because that's
exactly.
in other states, right?
Yes,
it's a sizable percentage.
Absolutely, right. So here, you will typically find one of 2 ways of the costs being handled. So either it can be flat fee, or it will be based on the attorney's hourly rates. So, you know, it's whether that's setting up the trust up front or the estate plan up front, or handling the probate or trust or estate administration on the back end. So, you know, and a lot of times it can be hybrid. You know, I typically do a flat fee up front, and then for estate or trust administration, I do that hourly. But again, it's kind of going to vary between those 2. Yeah, you got it. It depends, right? You don't even have to go to law school. But yeah, so, you know, the will-based estate plan is going to be the less expensive of, you know, the will or the trust-based, right?
In terms of upfront costs.
Upfront costs, exactly.
Gotcha.
Right. So, for example, you know, it could be $2,000 to do a will-based estate plan, and then $5,000 for a trust-based estate plan.
Okay.
So, you know, you're like, oh, $2,000 is less than $5,000. I like that one. Let's go with that one,
sure.
Right? And so,
but wait, there's more.
But maybe it depends.
Right?
But you know, then you look at things kind of down the line, and you're like, okay, well, so now somebody's passed away, and with the will, we have to go through probate,
Gotcha.
Right? And so there are going to be those fees, and I mentioned that the Colorado probate system is kind of set up similar to the IRS and tax filings, right?
Sure.
It's you're able to do this on your own. The probate forms are available on the Colorado Court's webpage. You know, so you could potentially, I'm not, you know, recommending one way or the other. It's, you know, it's just
choice,
it's your choice, right?
Sure.
Like if you feel competent to file your taxes, you're able to. You know, if that's not a strong suit for you, then, if you have trouble with math, maybe, hire a CPA.
Sure.
So the court costs and those initial probate fees, those are pretty low. There's a couple $100 to get it open, and there's some filing costs along the way. But if you're working with an attorney, that's where those costs are really going to come in. So it is entirely possible, depending on what kind of estate we're working with. You pay $2,000 to have the plan done up front, but then maybe it's going to be $3,500 to settle the estate. So it could potentially run more
than that.
Yeah. Not necessarily always. It's just, and I'm using those round numbers,
right.
the 2 and the 5. Those are,
just general figures
exactly.
off the top of your head. Mm-hmm. Not promises.
Exactly. Exactly.
Gotcha. But I guess, so let's say we go down the probate route, set up the will and that sort of stuff. So there's that upfront flat fee to get the will created. After the fact, then that would become an estate cost, right, for the attorney or something along those lines.
So so it's a timing issue, right? So you'd be paying the attorney to draft the documents up front, and then you are not responsible for paying the $3,000 that comes out out of your estate on the back end, right? But something I always do want to point out too to my clients, when because cost is very much a consideration. Yes, it might be less now, and we might be talking about $3,000, $3,500 for a probate, but that's in today's costs, right?
Sure.
Right. It might end up being more down the line, and more
Probably
likely than not, it will be.
Yeah,
Exactly.
Yeah.
Nothing goes down.
That is for sure. And then I guess, would it be the personal representative's decision on whether or not they wanted to use an attorney, or is that something that could also be put in the will?
Well, so the will is really just kind of more the legal guidance, saying, okay, this is who is going to be appointed, this is how it's going to be done. I've never actually seen someone put in to the will itself saying, I'm requiring my personal representative to hire an attorney. Okay. I could see that going in there. Oftentimes, that's something that I recommend to my clients, because the will, the trust, all of that, powers of attorney, those are just documents, right? They tell the courts what to do, but this is just as much of a conversation that you should be having with your key people, your personal representative, your trustees, your guardians, your powers of attorney, so they know what your wishes are, right? So, these should be conversations that everyone's having. I also am realistic and know that's probably not going to happen. But you can leave a letter to your personal representative or your trustee, kind of telling them your preferences, right? So, I think that is something that could be done.
Yeah, gotcha. But it's the personal representative that, if it's not a part of that will, that's going to have to make that decision.
Exactly.
And are they trained in law? Have they been through this process before? Is it contested at that point? And then you're almost forced to get an attorney.
Well, and the personal representative is a fiduciary role, so they have a legal obligation to the estate and the other beneficiaries. And sometimes actually that's where you can kind of see some gray areas, right? A lot of times parents have a couple different kids, 4 kids, or they name the oldest as the personal representative because that logically makes sense, and then that kid, because they were always the oldest, they knew better than everyone, and they're like, oh, I'm just going to handle this, and I'm going to save the estate some money. But maybe then we run into some issues, right? Because
violation of that fiduciary responsibility.
Right. Well, because maybe they're they think something's right and they're handling it that way, but maybe it's not fair to the other kids or something like that. And that's another time an attorney would be helpful in kind of helping keep that, not keep the peace necessarily, but just keep the priorities straight, right? And, say, okay, yes, I know you think that, keeping the family cabin and the family is the right thing to do, but is that going to be best for, like the market is hot, nobody lives, in Colorado or whatever the case is, and so it might make the most sense.
So you
to
bring up
set-
some questions or some
yeah.
thoughts that maybe that eldest isn't thinking about,
Right.
and point out some blind spots.
Exactly, yeah.
In your considerations.
Yeah.
Gotcha. So we talked a little bit about some of the costs, the hidden costs of probate. Any others that are out there? I mean, you got the filings, the notifications to
Sure.
the creditors.
Yeah, I mean, so I think there really aren't any costs upfront with the trust, right? There's, when you set it up, I mean, there's the initial upfront cost, but there's no cost of maintaining it. There's no tax returns because it's as long as it's the revocable trust. Irrevocable trust does have filing requirements, but kind of for our conversation today, we're just going to focus on the revocable.
Yeah.
So there are no filing requirements. There's no, Secretary of State dues that you're filing. It's really just an extension of you, right? So there's no costs there, and I think probably the biggest savings, if you will, are going to be more of an emotional situation, right? Like, it's not taking that emotional toll on loved ones trying to figure out, hey, did mom and dad really want us to keep that cabin? Or, I know it's been in the family forever, but maybe it makes the most sense, nobody's using it, let's sell it and, split the money. And, that kind of takes that guesswork out off the table for, the beneficiaries. And, I think that's probably something that's overlooked sometimes.
Gotcha. Okay. So last question I have for you, Renette, is somebody wants to find out that it depends for them.
Yes.
What's the process? Give you a call, set up a consultation?
Yeah, absolutely. I have I don't like it an initial consultation. That makes it feel a little too, I don't know. Formal, yeah. I mean, I'm about relationships. I think this is this is very personal, right? And so I prefer to call it a right fit meeting, right? So reach out, we can chat, whether it's in person, over Zoom, the phone, whatever works best. And, if we feel like it's, a good mix, then the next step would be to kind of start sit down and have a little bit more of a formal meeting where, we talk about kind of what the situation looks like. And because there is no one size fits all, right? It's not this is, you have these criteria, you are,
this circle that put you in that
exactly.
circle.
You guys are, just a couple, no kids, or a couple with kids, or a couple, and then it's just more of a, okay, well, what are we looking at? What are we, and then from that point, I can begin to kind of generate an idea of what we're looking at, right? And then what are the concerns and what's the long term, the big picture, right?
Yeah.
And, sometimes cost is much more of a concern, especially with young kids and everything. And so, there's some other options, kind of like hybrid, if you will, of a will with a trust that would spring from it. That's known as a testamentary trust. So there's a number of different options. It's not just will or trust, but it just depends on what's right for everyone. So
the right fit.
Yeah, the right fit. Exactly.
I like that.
There
That's a great name for it. So if you're interested and want to determine if it's a right fit for you, to talk to Renette. We've got our contact information all over this. Feel free to reach out and get that process started. But it definitely sounds like there's layers and steps. It doesn't have to be one direction or the other right from the start. You can start kind of putting the bricks in place and build on it over time.
For sure.
And at least you'd have something in the case of
worst case scenario. Yeah, exactly.
Something happening there.
Yeah.
Awesome. Well, thank you for tuning in. We hope you enjoyed it and got some great information. If there's anything that Renette or myself can do, feel free to reach out.
Thank you so much. Thanks, Keith.
Thank you.